Hi, Mike Wolpert from Wolpert Insurance Agency, and welcome to part 2 of our video blogs on workers' compensation. This week we're going to talk briefly about the employee's right to sue the employer and others, and how you as the employer could run the risk of still being sued. Does the employee have the right to sue their employer if they're injured at work? The answer is kind of complicated, unfortunately. Kind of no, kind of yes. Technically, the employee waives their right to sue when entering into the workers' compensation system. That's part of the trade-off that was structured well back years ago when the states individually adopted workers' compensation as the protection for injured employees. Up until that point, employees had been required to sue their employers, and unfortunately, because the employee did not have the money to spend for proper representation, they were oftentimes losing cases that realistically they probably should have been entitled to collect on. So in exchange, the workers' compensation system came into play, where the employee gets a guaranteed right to collect if injured at work, and in exchange for that, they give up their right to sue the employer. Unfortunately, that's, as always, not the entire story here. A little bit more to this story is the employee's right to sue third parties. Let's say, for an example, that you're a manufacturer and your employee is working on a machine and gets injured because of a malfunction in the machine. Well, the employee certainly doesn't have the right to sue you, the manufacturer, but they do have the right to sue the maker of the machine. Depending on your contract with the maker of the machine, that may not be an issue for you as the employer. But in some cases, for example, we've had companies with drivers who are injured at the work site of their customers. And in that case, they have the right to sue the customers for third-party negligence, even though they're collecting under workers' compensation. The downside to that is that you, as the employer and as the provider of services, may have signed a contract that holds your client harmless for any damages that develop as a result of your operations. So in that case, that suit would flow back to you and to your workers' compensation policy potentially, and would give the employee the right to collect additionally possibly. Likewise, there are situations, you've probably heard the term loss of consortium. There's obviously jokes that go around based on the terminology loss of consortium, but basically the term refers to any and all services that an individual is able to provide. So both a spouse as well as any dependents can technically sue for loss of consortium. For example, if I'm injured at work, I may be unable to support my wife and children outside of financially, but I may not be able to pick up the kids at school or take them on their various runs to their activities or things like that. So those are the situations where the employee, while prohibited technically from suing their employer, can potentially work around the system and find additional compensation. Obviously, while the principle is fairly consistent state to state, some of the technicalities do vary, and we'd encourage you to call us or your local agent if you have any questions. Thanks very much. Have a great day.